Welcome to the City Club of Eugene's December 10, 2021 program. Measure 11 mandatory sentences: repeal, revise, or retain. This is the 13th program for our 2021-22 programming year. My name is Kitty Piercy, and I am the City Club President. Support for the club is provided by our members and sponsors. You can become a member of the City Club at our website, cityclubofeugene.org. Our programs are always available on our YouTube channel, our Facebook page, and our podcast is available wherever you listen to podcasts. Programs are broadcast on public radio station KLCC 89.7 on Monday nights at 7. We have both business and in-kind sponsors, including our diamond sponsors, Kaiser Permanente, University of Oregon, Peace Health, and Lane Community College, as well as generous support from the City of Eugene and from Lane County. In today's program, we welcome speakers Floyd Prozanski, Oregon State Senator from District 4, and Patty Perlow, Lane County District Attorney. And today we'll have a first question from retired Oregon Supreme Court Justice David Brewer. Biographical information on our speakers is available on our website, cityclubofeugene.org. I'd like to thank Andrew Kallick and Joel Corrin for coordinating today's program. Measure 11 mandatory sentences: repeal, revise, or retain. Measure 11 is a state law that sets minimum mandatory sentences for certain crimes. It was approved by ballot referendum in 1994 by a nearly 2/3 majority of Oregon voters and went into effect on April 1, 1995. It was reaffirmed by the voters in 2000, but has also undergone several revisions in its nearly 30-year history. Legal scholars and lawyers have long debated what is the correct mix of the various goals of sentencing: punishment, rehabilitation, deterrence, or just separation from society. In recent years, criminal justice reform advocates at the local, state, and federal levels have focused attention on mandatory minimums, alleging that they have contributed to over-incarceration and have been applied in a discriminatory manner. Oregon State Senator Floyd Prozanski has introduced a bill to do away with all mandatory sentences except murder, giving the trial judges more discretion in sentencing. Another bill would allow Measure 11 offenders a chance to get out early release on early release credits. Defenders of mandatory minimums, including many of Oregon's district attorneys, argue that the provisions contribute to clearer, more consistent sentencing and have played an important role in the sharp decrease in crime that the state has witnessed since 1995. We'll hear from two speakers who are involved with these issues every day: State Senator Prozanski and Lane County District Attorney Perlow. They will provide different perspectives on the best course of action for Oregon moving forward. Our format today includes a question and answer period with City Club members and non-members alike via Zoom.
This is Andrew Kallick, and welcome to the City Club of Eugene. Before Senator Prozanski and District Attorney Perlow dive into their perspectives on Measure 11, we wanted to provide a brief Measure 11 101 for our listening audience. Measure 11 was a citizens' ballot initiative that was enacted by a nearly 2-to-1 margin in November 1994. The measure required mandatory minimum prison sentences for 16 serious offenses and forbade reductions in a sentence for good behavior and/or parole prior to serving the minimum. The measure also required that youth age 15 and older charged with one of those 16 crimes be tried as adults. A companion measure, Measure 10, also passed, which allowed the legislature to change Measure 11, but only by a 2/3 vote of each chamber. Since that time, the legislature has amended Measure 11 on numerous occasions, including adding crimes to the list of mandatory minimums, providing judges with additional discretion for certain crimes, and most notably, a series of changes in 2019 that altered the applicability of Measure 11 to minors in response to a series of decisions by the Supreme Court of the United States, which related to the constitutional rights of children in the criminal justice system. In 2000, a ballot measure that would have repealed Measure 11 completely failed by a nearly 3-to-1 margin. However, in recent years, there have been renewed calls by certain stakeholders for fundamental reform of Measure 11, many of whom assert that Measure 11 has contributed to over-incarceration, with people of color facing the brunt of the impact. At the same time, others continue to oppose the repeal of Measure 11, asserting that the measure makes Oregonians safer and ensures transparent, consistent sentencing. We're lucky to have two Measure 11 experts with us today to dive deeper into this important component of Oregon's criminal justice system. Senator Przansky, you'll be first, and then we'll hear from the district attorney, and then Q&A from our audience. Senator?
Thank you very much. Good afternoon, everyone. Thanks to the City Club, Eugene City Club, for hosting today's program on the bad and the ugly of Measure 11, mandatory minimum sentencing. As a prosecutor in this state for the past 34 years, I'm here to tell you why it is important for us to return sentencing decisions involving person felonies to judges and to return the prosecutors to their role as advocates and to remove the unbridled power mandatory minimum sentences has given to them. The history shows that prior to the passage of Measure 11 in 1994, for 135 years, it was the job of judges in Oregon to determine the appropriate length of sentence for person felony cases, not the prosecutor. Instead of allowing judges to use their discretion to fashion a sentence based on the specific facts in a case, Measure 11 created a one-size-fits-all sentencing structure. No matter if the defendant was a first-time offender or a career criminal, they received the exact same sentence. In the 26 years since Measure 11 became law, we have seen the inequity of the one-size-fits-all sentencing scheme. In removing the discretion from the judges to impose tailored sentences for specific facts and circumstances in a particular case, what we have seen is a shift of Measure 11 actually becoming what's known as a one strike and you're out sentencing structure. Again, even though a person may have no criminal history, they will receive the exact same sentence, of mandatory minimum sentence, as a career criminal. Even though judges may consider aggravating circumstances raised by the district attorney, they are prohibited from considering any other circumstances that may be mitigating factors for consideration in sentencing. In other words, the district attorney is allowed to ask for longer sentences based on aggravating circumstances around the crime, but the defendant is prohibited from asking the court to impose a more lenient sentence based on mitigating circumstances, such as being a juvenile, being a first-time offender, or a person who has experienced childhood trauma that caused the issues that brought them before the court. In other non-Measure 11 felony cases, judges consider all of this information and reports, both from the district attorney and from the defense, before pronouncing what the individual sentence will be. Judges have complained through the years that the mandatory minimum sentencing demanded by Measure 11 often is inappropriate. Further, that even though the legislature amended Measure 11 as it applies to youth, it still applies to youth as young as 15 years of age. Measure 11 shifted the power decision process from the judge to the district attorney when it comes to sentencing, again, individuals as young as 15 years of age. Now, Measure 11 was instituted, as I mentioned, 26 years ago, putting the district attorneys in what I would call the catbird seat. Measure 11 made it possible for district attorneys to stack unreasonable conditions on crime suspects to accept a deal. Well, let me give you some examples of how egregious these conditions can be. For a person to forego any appeal rights, for a person to not be able to participate in rehabilitative programs while they're in custody, and in fact, to receive a longer sentence for a charge that they will plead guilty to in accepting a deal that would keep them out of the mandatory minimum sentencing. Voters never intended that judges should lose their discretion when they are in sentencing phase. They did not intend to shift the balance of power and control to district attorneys in negotiations, but that is what the results are when you have a mandatory minimum sentence process. Last December, December 2020, The Oregon District Attorneys Association, ODAA, commissioned a survey poll of registered voters concerning mandatory minimum sentencing. One of the questions they asked actually got a response that 58% of those polled supported replacing Measure 11 sentences with discretionary sentences that would provide for judges to make with a suggested range of imprisonment, the decision of how long a person should serve. A recommended sentence is what that would be considered. And then at that point, the judge would be able to, one, take in any information that the prosecutor would want to argue for a longer sentence if they had aggravating circumstances. It would also allow for defense or the defense attorneys to ask for a mitigated sentence, a lower sentence, if they had facts that would in fact show that it was just in that particular case. This is exactly the same way that non-Measure 11 felony cases are sentenced in Oregon today. Even though their poll shows Oregonians want to put the discretion back into the judge's hands and remove it from a mandatory minimum sentencing, ODA continues to oppose judicial discretion for one simple reason: to retain the unbridled power and control district attorneys have under Measure 11 with mandatory minimum sentencing. Measure 11 puts the defense attorneys, I said, in this catbird position, and they are not willing to give that up because they understand and they now live on the power and the control they have in this process. To address this unfair balance of power, the legislature should make the current Measure 11 mandatory minimum sentences what's known as presumptive sentences. As I mentioned before, this is exactly how we have cases processed for sentencing that are not Measure 11 offenses today. In other words, what we would see is that the sentences would become a recommended sentence, but the judges would have the discretion to require either a longer or a shorter sentence to be imposed based on the particular cases and the facts that arise from that case. Both the district attorney and the defense attorney would continue to be advocates in the courtroom. They would be expected to put their points of law and facts supporting their recommendation before the judge, but then the judge, not the prosecutor, would decide the appropriate sentence. It must be noted that some district attorneys have even said they don't trust judges who stand for election by the people of Oregon to actually provide a sentence that's fair and just under the circumstances. Let me say that one more time. There are DAs in this state that do not trust judges to properly sentence an individual. That viewpoint shows why the unchecked power that they've received over the last 26 years has warped their perception, and we need to go back to the basics of what we've had before. Since the founding of Oregon 162 years ago, the sentencing has always been vested in the judges, not the prosecutor. The power to impose sentences is one that should be left with the judges. And this is time for the legislature to fix this broken process and system. It also should be noted that ODA is still promoting false premises that Measure 11 caused violent crime rates to go down when it passed. It did not. Nationally, at the same time that Measure 11 was being voted on by the people in 1994, the crime rate was already going down across the nation, including in Oregon. It continued to go down even with the passage of mandatory minimum sentencing. And it didn't matter whether the state had mandatory minimum sentencing or not. They saw the reduction overall in the violent crime in their states. Currently, the nation is now, including Oregon, is seeing an increase in violent person crimes. So if ODA's premise is correct or was correct, which it wasn't, that it reduced these crime rates and these crimes, why is it going up now? ODA cannot have it in both ways. They need to come clean on this. I hope that DA Perlow will provide us with answers today as to why violent person crime rates are going up when we have Measure 11 in full effect for the last 26 years since ODA sold this as a means, and they have demonstrated through their own polling and their press releases in the last year that they believe that it was because of the passage of a mandatory minimum sentencing that the crime rates went down. But today, as I said, they're going up. I also hope that ODA and DA Perlo will honor the will of the voters shown in their own poll again and relinquish the unbridled power and control that Measure 11 gave them. But unfortunately, I expect that DA Perlo will continue to rely on the stories of blood and guts to traumatize and put fear into voters and why they need to maintain the unbridled power and control they have gained under Measure 11. As I stated before, it is time and past time for the legislature to take action. It's time for the legislature to return sentencing to judges, remove the power and control DAs gained under mandatory minimum sentencing. I hope that we will, in fact, do that as the legislature in the very near future. Thank you very much. I'll pass it to my colleague, DA Perlo.
Thank you, Senator Przansky, and thank you to the City Club. It may be disappointing to you to hear that I am not here as an advocate for Measure 11. I'm here as an advocate for having the voters decide and an informed electorate decide whether or not to retain the mandatory minimum sentences imposed by Measure 11. I'd like to start with a little history about sentencing in Oregon. Prior to 1989, judges had full discretion to sentence any offender, misdemeanor or felony, up to the statutory maximum. And so for a Class A felony like rape in the first degree, burglary in the first degree, assault in the first degree, manslaughter in the first degree, a judge could sentence an offender to probation or a sentence up to 20 years in prison. I have a file in my office right now. It's a 1988 rape of a child case, 5-year-old, by the stepfather, because the child, I'm assuming looking back at the file because it's so old, that the prosecutor resolved the case for a sex abuse 1, despite the terrible facts, because the child couldn't qualify to testify as a witness. And so it was resolved for sex abuse 1, which in 1995 became a Measure 11 offense. The white male defendant with the retained attorney was given probation and ordered to attend sex offender treatment. Shortly thereafter, the sentencing, the defendant fled the state of Oregon, did not attend sex offender treatment, despite a sex offender evaluation saying how very dangerous this person was untreated in the community, and absconded for 10 years before he was captured in another state and extradited back to Oregon. And so that's what sentencing is like with unbridled discretion. The legislature in 1987 passed laws creating the sentencing guidelines and giving control to the Criminal Justice Commission on what the appropriate sentence range would be for a judge to consider. So it's not exactly honest to be saying that we should be giving discretion to judges to decide what the sentence is. It's actually the Criminal Justice Commission who dictates to judges what the sentencing range will be. And so it's based upon the crime seriousness and the criminal history of the defendant. And so for, let's say, assault in the first degree, somebody intentionally causes serious physical injury with a weapon to another person. One example is with firearm, shoots the person with the intent to kill them, but because we have great trauma care, the person doesn't die, survives, and has debilitating injuries for the rest of life. Under the sentencing guidelines, that person could be sentenced, let's say he has one prior person felony conviction for between 91 and 110 months in prison. Under Measure 11, that person would receive 120 months in prison as a mandatory minimum sentence. Of that 91 to 110 months, that person may only serve half of that sentence because of the allowance of programs and the control of the Department of Corrections. And so when a person is a victim of crime going into court and the judge is announcing what the sentence is, when it's a Measure 11 sentence, the person can be confident, the victim can be confident that that person is serving the sentence that was imposed by the court. When it's a non-Measure 11 sentence, the person can be released with having served up to, well, as little as half of the sentence imposed. And so then the victim does not have any confidence in the sentencing. And the court doesn't tell the victim that the person may be released from custody having served as little as half of the sentence. It is up to the district attorney to let the victim, and victim services let the victim know that it may be just a matter of, in this case, 46 months before the victim would see the defendant back on the street in the community. Victims lost their voice in Oregon. They finally achieved a voice in Oregon in the 90s and maintained that into the early 2000s, and then the organizations became complacent. And so victims have lost their voice in Oregon, and the narrative has turned to that the defendants, the people who are committing these heinous crimes, are who we should be considering first in these circumstances. Now, if the voters decide that's the case, then we should just follow the rules as established by the voters. And my office will follow whatever the law is with regard to sentencing. But I'm asking that the voters be allowed to make that determination based upon an honest narrative about what that means. Under Measure 11 currently, all of the second tier crimes, assault in the second degree, rape in the second degree, sodomy in the second degree, manslaughter in the second degree, unlawful sexual penetration with a foreign object in the second degree, the judge can take the defendant out of Measure 11 and sentence pursuant to the guidelines, or even less. The judge has authority to put a person on probation who would otherwise be required to serve a prison sentence, even under the guidelines. And so honesty in these conversations needs to include that judges do have discretion on the second tier crimes. The only crimes that the judge is sentencing to a mandatory minimum service are those assault in the first degree, rape in the first degree, sodomy in the first degree, manslaughter in the first degree. If somebody has an extremely violent prior history on an assault in the first degree, the judge could sentence them up to 130 months in prison. And in fact, could sentence longer if there were aggravating factors. The only thing the mandatory minimum does is make sure that they serve that first 120 months of the sentence in prison. After that time period, the Department of Corrections has control over what will happen to the defendant and when the defendant will be released. And so it is just setting a minimum for what somebody who commits one of the most heinous crimes in our community is going to be serving. Since, going on to the Criminal Justice Commission's website, over the last 6 years in Lane County, we've had 803 people between 2013 and 2018 charged with Measure 11 offenses. And that was consistent from 1995 to about 2021. We have had violent crime, and the senator's right, violent crime is booming right now. By the end of October of this year, we had already received more Measure 11 offenders into our office for review than all of 2020 or 2019. And we're on par to be at a record pace for these violent felons coming into our office for review for charging. But we haven't processed any of the cases over the last couple of years because of COVID. And so between now and the end of 2022, as of yesterday, we had 721 cases set for trial. 721 cases are set for trial between now and the end of 2022. And we have violent offenders who are awaiting trial who've been released from the jail because you can't hold them for greater than 60 days if you can't bring them to trial, and unless the court finds compelling reasons otherwise. And so when the senator's asking, why is violent crime up in our community? There are a lot of factors that have to do with that. One of them is no offender accountability in our community when somebody commits a violent crime. Number two is, if you look at the Criminal Justice Commission assessment of what caused the reduction in violent crime in the state of Oregon, one of the factors was a lessening of risky behavior. Well, we have increased risky behavior dramatically over the last couple of years. People are driving too fast, and our traffic fatalities are up, which would be, the manslaughter charges under Measure 11. And people are using drugs in the park, and they're in drug-induced states committing violent crimes against our other unhoused population. We have people fleeing the Eugene area as unhoused to Florence. And so that Florence is in a situation where they don't have resources to attend. And the people are fleeing Eugene because it's too dangerous to be unhoused here. So when you say, what's causing the increase in violent crime? Yeah, there are a lot of factors that have to do with it and have nothing to do with Measure 11. We aren't imposing those sentences. We aren't imposing any sentences currently because of the backlog of cases that have happened over the last 2 years. So there are a lot of factors, but yes, not sentencing violent offenders is one of those. When you talk about whether or not we should maintain Measure 11, I don't have a stake in it. It isn't about power to the prosecutors that Measure 11 provides. It's about providing a truth in sentencing and accountability for the most violent offenses that people in our community commit. And the people of the state of Oregon determined what the minimum sentence for these most violent offenses should be. And the legislature has had the opportunity to make some adjustments to that, particularly to the second tier crimes. And they've removed juveniles from this completely. And so that shouldn't even be a factor that we're talking about. There is no circumstance under which a juvenile can be waived to adult court for committing a murder or a rape or any other crime under Measure 11 because of the way the law was written by the legislature. And so all juveniles are handled through juvenile court, regardless of the level of offense that they commit, and are under the jurisdiction of the juvenile authority, the Oregon Youth Authority, up to age 25. So I'm not going to spend any more time talking about that. I look forward to the questions that are going to be coming up here, because I think what's really important is an honest dialogue about what the impacts are of the sentences that are imposed and what the impacts are if you remove the mandatory minimums for these really violent, terrible crimes. And I understand questions are next.
Thank you both so much. Now we're moving to Q&A, and we're fortunate to have David Brewer with us to ask the first question. A graduate of the University of Oregon Law School, Dave is a retired justice of the Oregon Supreme Court, where he served from 2013 to 2017, and a former judge on the Oregon Court of Appeals and the Lane County Circuit Court. Justice Brewer, thanks for being with us.
Thanks, Andrew, and good morning. And I want to thank Ms. Perlow and Senator Prozanski for their informative presentations, which are, I think, what we desperately need now. Even after as many years as Measure 11 has been in effect, I'm always struck when people ask me about it, whether they oppose it or support it in some form or another, how much of the reaction I get seems to be either emotional or anecdotal. So I'd like to focus on something that you both touched on, and that is how reliable data can help voters understand the impacts of Measure 11 and whether and to what extent it's worked as intended. In March of this year, an Oregon Criminal Justice Commission report touched at a general level on whether and to what extent the implementation of Measure 11 itself has lowered serious crime rates in Oregon. And it also noted briefly the question of how its implementation has affected other sentencing policies in Oregon. Now, as you both alluded to, recognizing that any credible evaluation of Measure 11's impacts needs to account for a complex mix of external factors, what can the available data, the best data, tell the public about whether and to what extent Measure 11 itself has lowered crime rates or has had a tendency to lower crime rates for the most serious offenses, and about its impact on other legally established sentencing policies? As a follow-up, if current analytic models are inadequate to answer these questions, what more can be done to give the public a better informed picture of the situation? Thank you.
And I'm not sure, but I'm assuming that at this point, each of us should be answering the questions. Or what's the process? How did you want to do it?
Yes, unless the question is targeted to one of you. So feel free, both of you, to answer this one. And if you want to start, Senator, this time, that'd be great.
All right. All right. Justice Brewer, thank you very much for the question. It is very complex, as you've stated. Let me give you the answer to the second question first, because I think this is the most important part for Oregonians. And that is that we need to invest additional resources to the Criminal Justice Commission, who is in fact our go-to agency to give us these type of answers. We need to support that operation by providing for at least one FTE to actually go in and really drill down and dive down into this discussion and do the research that is necessary for anywhere from a 6-month to 1 year period of time. This is what I've been told by the director as to what is needed. And then we would actually have hard fact evidence as to the best we have from the data that's there as it pertains to Oregon. Now that since we don't have that, I think it's important for us to look at what we do have. And again, what the Oregon District Attorneys Association has stated in the past, and is as recently as January of this year, stating that Measure 11, in their perspective, actually caused violent crime rate to go down. Now, what we do know is that when it was passed in 1994, we saw crime rates going down across this nation. Some states had mandatory minimum sentences, but most did not. And so how do you justify the increase or the reduction based on that type of data and statement? What it shows to me is that in this particular case, when Measure 11 was passed by the voters, it had no impact on the violent crime rate because, as you've said, Justice Brewer, there are many external factors that go into this, including the state of the economy, the state of what we're dealing with right now. I would say part of the issues of why we see the increase in the violent crime rate is because of the COVID situation and what occurs from that as to people being isolated out from each other, being able to participate in jobs, and being able to actually provide for themselves and their families. Those are the type of scenarios that have in fact had a direct issue. And this is the part that I find very troubling, to have the Oregon District Attorneys Association continue to say that Measure 11 was the reason that we saw crime rates go down in this state, when at the same time, other states were seeing that reduction and saw that reduction for about a 25-year cycle. Now we're entering into another cycle. And yes, I think DA Perlow and I agree. There are external factors that we should be working on in society to actually reduce that crime rate.
All right, well, I would also like to address the report that Justice Brewer mentioned that the Criminal Justice Commission put out last spring. And it does list a number of factors that created a reduction in violent crime. Included in that was, in fact, that Measure 11 could be attributed to some of the reduction in crime because people aren't committing additional crimes while they are incarcerated. And so the people who have been convicted of Measure 11 offenses, who were repeat offenders, people who had multiple crimes of violence, people who were sex offenders with multiple victims, are unable to continue that criminal behavior while they're incarcerated. So to that extent, yes, Measure 11 did have an impact in a reduction to violent crime. But as we've been discussing today, there are factors that have caused all over the country violent crime to increase dramatically. And even in our own communities, particularly in Lane County that I'm aware of, that violent crime is increasing dramatically. And the factors that were listed by the Criminal Justice Commission as reasons why crime reduced are in play now as to why crime is increasing dramatically. But as I mentioned before, it also includes that we aren't having any kind of law enforcement response to the violent crime that's happening in our community right now. And so to say, that these cases are just stacking up and we aren't addressing crime, and people who are committing violent crimes are released back into the community, and law enforcement can't arrest us out of this problem that we're seeing, where our community is becoming increasingly dangerous, particularly to our unhoused population, during a time when law enforcement is desperately trying to recruit people to come into the field, while the narrative has been so anti-law enforcement. And now we're discovering what is happening in our communities across the country and right here in our own backyard. So I would say there are many, many factors on what's happening with violent crime and our crime rates, but you can't say that Measure 11 didn't have any statistical impact on it. And I don't speak for the Oregon District Attorneys Association. I only speak for myself.
Thank you both. Next question from City Club member Mary Layton. Mary.
So I'm actually kind of stunned that neither of you mentioned this. I would have imagined one of the arguments for Measure 11 was to make it so that committing a crime while being a person of color got the same effect as committing a crime while being white. And yet you've produced no evidence that justice is served equally now that we have this matrix, this metric. And so this is a matter very much on my mind. It is the reason we're like backing off law enforcement, because clearly in the whole country and including locally, it's a worse offense to commit a crime, any crime, while being a person of color. So what I'm interested in is, how are you tracking the impact of this law across various kinds of neighbors in the county, for example, or the state?
I'll start on that one. So the Criminal Justice Commission, on their dashboard and in an additional report on Measure 11 that was put out last spring, other than the one that Justice Brewer was referring to, provides a lot of data on charging, disposition, and race. My obligation as your district attorney is not to consider anything other than the crime that was committed and the evidence, the admissible evidence that's available to prove that crime. We don't look at who a person is under any circumstance on whether or not to charge a crime. We only look at, was a crime committed, and is there sufficient evidence to prove that beyond a reasonable doubt? And the charges are based upon the crime that was committed and the evidence that's available. It has nothing to do with disposition. And I see you're making a face at me. Ethically, we have an obligation not to consider anything other than the crime that was committed and the evidence to support the commission of that crime in making a charging decision. And the notion that a district attorney would overcharge cases based on race or overcharge cases to get someone to take a deal is unethical conduct and prohibited in my office. So I can't control what the outcomes are with regard to who gets charged in our community. I can tell you that it is predominantly white people, predominantly white males that are committing crimes in our community and getting charged with them. But I cannot take into consideration when someone is charged with a crime what their race is, and I can't take into consideration at disposition what their race is.
Mary, thank you for that question. You know, one size fits all doesn't work. And this is one of the situations that why and how you can actually address these discrepancy is to give back to the court that discretion to actually take in all life factors of that individual, as well as the victim or the victim's families, as the situation may be, and also to take in consideration the need to ensure that justice is done, one that actually provides for a accountability for the individual, and at the same time in our restorative justice system reformation to actually have them have the opportunity when they're in custody to actually participate in programs. As I mentioned to you in my presentation, there have been deals that have been cut by district attorneys in Lane County as well as across this state that basically took away those rights of appeal, being able to participate in programs. Why? Why would you do that? Why would you stop someone from being able to reform their behavior come out better and being able to provide for themselves. And it is true, there is a disproportionate percentage of people of color serving sentences in the Department of Corrections here in Oregon.
I am very much aware of the fact that because I am of a certain demographic, the likelihood of my being busted for any crime in a serious way is very small, even if I were to commit one. And somehow the justice system has to account for the centuries-long habit of viewing other as likelier to be sinner. I'm not saying everybody's evil. What I'm saying is we are human beings with certain tendencies, and that causes, so Ms. Perlow, it causes us to arrest people, to charge them on the basis of some deeply ingrained prejudices, which we have not yet eradicated. And the evidence is very clear about that. So I think we need to work on it. Colorblind sentencing is not an answer in a system of justice that is too often influenced by color. But I have another question before you go. And that has to do with the homelessness thing. Yeah, oh, Andrew, you wanted to.
Yeah, thank you, Mary.
Sorry.
I'll come right back to you, but I think your question is an important one. I wanted to ask a follow-up because bias is long-standing, and it is often rooted not just in the race of the defendant, but in the race of the victim. There have been recent studies that have found that defendants, for instance, who are convicted of killing white victims, regardless of their race, as the defendant's race, they were executed at a rate 17 times greater than those convicted of killing Black victims. So there's been this argument, and Mary was getting at this, that limiting discretion can reduce either implicit or explicit bias in the system. Do you think that that's true? In other words, is one option potentially for reform to reduce the minimums because we think they're too great, they lead to over incarceration, but maintain the mandatory because there is a benefit, both a sort of racial equity benefit, but also a justice benefit in maintaining the consistency that mandatory might provide?
Yes. Yes, to touch on that, if you look at the demographics of victims of crime, they are disproportionately people of color, LGBTQ, so taking the consideration of the impact to the communities being victimized is equally important. But as I indicated early on, back when judges had full discretion, white guy with a retained lawyer and a job was treated very differently than somebody else for committing a violent rape against a child. And mandatory minimums have leveled that. And in fact, the incarceration rate of people of color, while it's still disproportionately high to the population, is less disproportionately high than it was prior to Measure 11, because most of the crimes are being committed by white males in this state, and they are being sentenced to a required sentence, the mandatory minimum. So yes, I agree with that completely.
All right, so Mary, Andrew, thank you for the follow-up question. So yes, I agree that if you lower the minimum sentence and a mandatory minimum sentence, that would somehow give us a different perspective to look at as to whether or not that actually serves the purpose of justice. I'm of the opinion that when the criminal justice system was established, it was to allow for discretion at the bench for the judge to make determinations as to a particular case. Any mandatory minimum sentencing structure, no matter what the length is called for, removes that. And to me, I think it's very, very important that we take in consideration and to allow for the judges, after they've heard the case, taking in the evidence, having a sentencing hearing, hearing from the prosecutor as well as the defense, from the victims and everyone else who are stakeholders in that process, to be able to then determine what is the most appropriate sentence to be given to that individual under the facts and circumstances. I believe that with a mandatory minimum sentence, no matter what the length is, you're going to see this disparity, and you're going to continue to see more people of color disproportionately being in the prison system than should be based on our general population of the different individuals in our state.
May I ask a question?
Sure.
Senator Przansky, how do you account for the implicit bias of judges? I mean, how do you take that into consideration in this notion that judges have full discretion in sentencing?
It's not full discretion, DA Perlow. Basically, what we're saying is that we're allowing an individual who stands accountable to the people of this state, because they have to be elected into their position. Even if they have been appointed, they still have to stand for election. So there is truth in going before the voters as to what you do as a judge. To discount the judge's ability and the trainings that they go through, I believe that you're short-sighting, and this is why I have issues with your position as well as many others in the ODAA not trusting judges. I mean, the system is set up for making certain there's balance. You, myself, as prosecutor, should not be the one that dictates what the sentence will be based on the charging that we do, and that we should not basically be able to then negotiate with such power over individuals to say, if you do not do these things, waive your right to an appeal, not participate in reformative programs to get a deal where you're going to spend a little bit less time, but actually maybe more time than you would get if you were actually charged with that offense on the outside, outright. This is not a system that's working. This is why after 26 years, we, the legislature, under the 10th Amendment, should in fact actually go in and make these changes under Measure 10.
Why wouldn't you want the voters to have a say in that?
The voters had a say in that. In 1994, when they passed Measure 11, they passed Measure 10 simultaneously within 1 percentage point of 64 or 65% of passing both of those. They told the legislature then, we understand there are going to be reasons why these mandatory minimum sentences should be changed. And let's not discount what we're actually talking about. We're not saying take them away. What we're saying is make that the presumption sentence, make that to be the presumed sentence that a person will receive unless the district attorney, through aggravating circumstances, show that it should be longer, or allow for the defendant to show under mitigating circumstances it should be shorter. So all we're doing is following what we do now, as you said, DA Perlow, regarding the sentencing guidelines. We're just saying, let's take Measure 11, mandatory minimum sentences, let's make them be the same thing as the presumptive sentence, and then we'll let the two advocates go in there and provide to the court all of the facts and data they want, and then allow the judge to make that decision.
Would you give the judge authority to impose a mandatory minimum? Would the judge be able to say, this is the minimum amount of time you have to serve in this case? Kind of like the firearm minimum.
I believe that a court has that inherent authority to put mandatory minimum type of length of sentences. The point that I think you are losing and missing out on, DA Perlow, is that in our system, we're trying to reform people. If someone goes into custody into the Department of Corrections and actually does everything they're supposed to do, and they actually improve themselves in prison, why would you want to keep them in prison for an extended period of time when they could be out of the prison, opening up a bed for someone that's more needy, and actually allowing someone that has actually reformed their conduct to come back into our community and actually be a working member of our community and actually provide for themselves and their families without being on the taxpayer's dollar for being incarcerated?
Thank you. We'll have to have you back for another hour in which you could just ask each other questions, because it's great. But Mary Layton, you have another question for our panelists.
Yeah, and I think Kitty will remember these days. When I started teaching, everybody thought it was good to smack a kid if he was bad. And eventually the evidence showed us that all that did was teach the kid smacking was okay. And we learned how to effectively get rid of the bad behavior using other strategies. I think that's maybe what Floyd is addressing. Not about no safety, but about better strategies. But I have another question. This was actually given to me. Although the DA is a state office, the state does not fund deputy DAs. And it sounds like our office, the district attorney, is a little bit short-staffed. To implement your proposal, more deputies would be necessary to have more robust sentencing procedures. Would you support that? Senator Brzezinski?
Oh, I absolutely would support making sure that we have enough resources throughout the system. I mean, we know that if you upload or overload any part of the criminal justice system, you're going to imbalance in the other areas. In this particular case, I think it's worth noting for the listeners of this program is that the district attorneys are in fact state executive officers, and their pay does in fact come from the state. They also receive a supplemental in most counties to the state salary they receive. And it's also true that at the county level, they have the responsibility of funding for their offices, the deputy district attorneys. But there's also a stipend or a small amount of money that comes in from the state to offset or to include for the deputy district attorneys. I would have no problem having that increased. But at the same time, I also believe that we need to realize is that the counties should also be looking at what services are they gaining from the state and the sense of incarceration at the state level as compared to the county level, and what is the best needs of the community, and ensuring that a person who does commit a crime such under Measure 11 doesn't commit it in the future by getting them the tools and mechanisms to understand and to do better in life and not to continue to be a repeat offender.
May I just provide a little information about funding of my office? The state only pays for my salary. There is no stipend for the deputies. We do receive some grant funding for victim services, and one of my lawyers is funded through Justice Reinvestment for the treatment court. But the rest of it is from the county general fund, and I currently have 21 lawyers in the criminal division. I'm funded for 23, trying to fill 2 positions. And as I mentioned, a record number of cases set for trial. And so it's, the system is broken. Even if the county had the money, which it doesn't, to fund my office more robustly, I don't have any space to put more people in my office because I'm housed in the old courthouse and there isn't any place to put more people. And so if I could get out of this building, and if the county had more money available to it, or if the state was meeting its obligations to actually fund adequately the system, then we would be able to do the kind of work that you're talking about. But right now we're in triage mode.
Thank you. We only have a couple minutes left, but Kitty Piercy, do you want to close out with one more question?
Maybe my question was too big to didn't do in that time, but I really appreciated your comments earlier about the juveniles not being held in the adult system and going to the juvenile system. But I want to understand how Measure 11 intersects with youth in terms of that juvenile system, or how does it in the long range affect if they created what is called a Measure 11 crime? I honestly don't understand how those things intersect.
They do not intersect any longer. Senate Bill 1008 took juveniles out of Measure 11. So a juvenile who commits what would be considered a Measure 11 crime, rape 1, assault 1, arson 1, manslaughter 1, is handled strictly through the juvenile court.
Which doesn't have Measure 11.
There's no Measure 11, and the standard or the requirements to waive a youth into adult court so that you could treat them as an adult or try them as an adult, that standard is unachievable the way the law is written. And so as we've seen around the state, no child, regardless of the nature of the crime, we had a youth kill a homeless man with a rock here and had assaulted another homeless man the night before with a rock, could not be waived into adult court. It is under the jurisdiction of the Oregon Youth Authority to age 25 from age 17.
Thank you for that information.
Terrific. Maybe we can do a lightning round. Mary, you got a quick one.
Well, this goes back to something Ms. Perlow said a little bit earlier about the rate of criminal offense in the homeless population. And I wondered, because you're obviously quite aware of the data on this subject, if you are participating in the Chamber's homeless consortium work, because that definitely needs to be a collective impact project in which all the players figure out what they've got to contribute. And certainly safety and security is an important issue. So I just wondered if any of your team were participating in that initiative, which is intended a public-private activity.
So from a different perspective is I have requested our Public Safety Coordinating Council bring a member from the Chamber, the business community, back to the PSCC to provide that information and the interrelationship. That the body, the PSCC, is made up of all parts of the public safety system, including treatment, Oregon Youth Authority, mayor, city administrator, police chief, state police, to come in and talk about all of these issues on a larger scale and try to come up with solutions. And the business community voice has not been part of that for over a decade.
Thank you both so much. That's all the time we have. We will have to have you back because there are so many other criminal justice issues that we could benefit from your wisdom on. But until then, and until next time, I'm Andrew Calick for the City Club of Eugene. Thanks so much for joining us.
This has been our December 10th, 2021 program. Measure 11 mandatory sentences: repeal, revise, or retain. Before we proceed, I'd like to recognize our diamond sponsors. Kaiser Permanente exists to provide high-quality, affordable healthcare services and to improve the health of our members and the communities we serve. More information at www.kp.org. Support also comes from the University of Oregon. Since 1876, UO has helped Oregonians question critically, think logically, reason effectively, communicate clearly, act creatively, and live ethically. More information at uoregon.edu. Peace Health. Peace Health is proud to serve Eugene, Lane County, and beyond. As your hometown healthcare partner for more than 80 years, our mission is to keep you and your family healthy. Learn more at peacehealth.org. Lane Community College. Lane Community College transforms lives through learning. LCC provides comprehensive, accessible, high-quality educational opportunities that promote student success. For more information, visit lanecc.edu. We also thank the generous support from the City of Eugene and from Lane County. I would also like to acknowledge our Sapphire sponsor, Bennett and Dean Real Estate. Support comes from Bennett and Dean Real Estate, a full-service real estate brokerage offering a comprehensive range of services for buying or selling a Lane County residence. For more information, visit bennettdean.com. And our gold sponsors, AARP of Oregon and Levas Cobb. Before we thank our speakers today, I have a quick announcement. Thank you to our in-kind sponsors, KRVM 91.9 Radio, PAC Info and Simplified Computing LLC, Dotson's Photography. And a special thank you to public radio station KLCC FM 89.7 for airing City Club programs on Mondays at 7. Our programs are always available on our YouTube channel, our Facebook page, and our podcast. We invite anyone, members and non-members, to participate in a Zoom taping of our programs. If you would like to join us or take part or ask a question during a recording, please visit our website. Note that sessions are scheduled at the convenience of the speakers and times vary. More information is on our website, cityclubofeugene.org. Next week, we have a special occasion. We will have our annual Gifts to the City program with Silky Booker, Gabe Castile, Karen Clark, Aisha Elliott, Roger Jensen, Ryan Moore, Lily Reynolds Parker, Helen Shepard, AKA Galaxy Cosmos, Sandra Shotrich, Beth Stein, and MC Dan Bryant. So you'll want to join us again on December 17. More details and information about programs, future programs can be found online at the City Club's website, cityclubofueugene.org. Now, I would like to thank today's speakers for a great program. Thank you so much to Senator Brzezinski and Patty Perlow. Thank you both very much for a great program. We appreciate you. And this concludes today's program. Be well and stay safe.